I'm Suryani Sulong on behalf of Sultan Ahmad Shah Medical Center at IUM. We are pleased to welcome to all of you to our very first legal webinar, Informed Consent and Ethical Obligation or Legal Compulsion. Ladies and gentlemen, we are pleased to welcome our beloved Hospital Director, Prof. Dr. Muhammad Safi Awang to deliver his opening remarks. Please welcome Dr.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And very good afternoon to everyone. Thank you very much to the chairperson, Ms. Suryani, and also the Office of Legal and Governance, SESMEC, for giving me the opportunity this afternoon.
I think turn off the lights.
Which is on the informed consent and ethical obligations or the legal compulsions. So I'm sure that everyone, as a provider about informed consent for medical student or medical practitioner, including anything, I'm sure during your training, you have heard about informed consent. So this is very important issues, in particular when we practice in the hospital. I think all of us may think that we know a lot about informed consent, but there are many issues surrounding informed consent that we still do not know. For example, if I can quote, in a situation like if a patient has 3 or 4 wives, so who should give the consent, right? And also a situation where in the same hospital, different wards may have different sets of rules or understanding about the same scenario. So these are the issues I think that will be highlighted and discussed by our speaker today, Mr. Jayananda Rao. So on behalf of hospital, I'd like to thank Mr. Jayananda Rao for joining us this afternoon. I hope you will be able to enlighten us more about the informed consent. So once again, I'd like to thank and congratulate the Office of Legal Governance. I think this will be the first of their many series of legal webinars that they will organize, and also to all the participants that participate in this afternoon session. I hope you will take this whole opportunity to ask as many questions as possible, so that everybody clear on the form of informed consent. So with that, thank you very much. Over to you, Ms. Suryani.
Thank you, Prof. Dato, for this wonderful remark. Today, Mr. Jayananda Rao has been in practice for the last 26 years and has his own legal establishment since 1997 under the name and style of Messrs. Rao and Kamal. Mr. Rao's primary areas are law as well as labor and insurance matters. Mr. Rao engages extensively in advising clients of the firm on matters concerning Industrial Relations Act, quasi-criminal matters relating to government departmental summonses for offences under Environmental Quality Act, Health Ministry summonses, immigration summonses, and the likes. Apart from the above mentioned, Mr. Rao is providing advisory services on fraud management to corporations on all forms of white-collar crime ranging from money laundering to commercial fraud, criminal breach of trust, as well as advising corporations and companies in relation to the implementation of corporate liability under the MACC Act. All right, without further ado, we humbly welcome our honorable speaker, Mr. Jayananda Rao, advocate and solicitor, to deliver the talk. Mr. Rao, the time is yours. Thank you.
All right. Good afternoon, everybody. Dato' Encik Hazrul Suryani, thank you for welcoming me and giving me this opportunity to give this talk to all of our esteemed participants. The topic, as we know, is informed consent. An ethical obligation or a legal compulsion. I'm going to share some slides with all of you as we go along this talk. Maybe it'll be easier to follow, and of course it could be also seen as a bit of a dry area, especially on a Friday afternoon after lunch. It'll be a bit difficult to concentrate, but please pardon me. I will try my very best to make it as interesting as possible. And please bear with me because this topic could be a bit lengthy as well, but I will be going subject per subject matter. Without further ado, let me just jump into the topic. Now, this is basically an area where it relates to the medical profession. As an introduction, I will just share the basic idea or tenets of what I'm looking at. It is it's not the introduction. Furthermore, yeah, just bear with me. Yeah, we're just sharing the screen. Okay. Now, as far as the introduction is concerned, it is in relation to the medical profession. Now, most of us will be asking, listen, what is the relevance that we have to be aware or wary about this topic? This is because that for the past couple of years, there have been some interesting developments in the area of law. The relationship between the doctor and the patient has become a prime mover for courts to see how this particular duty is imposed by a doctor or towards a doctor and by a patient and towards a patient. All right, now we know that because of this new technological era, most of the patients are educated, they know their rights, and more so, these rights are actually established in our federal constitution. If you look at Article 8, it gives the rights of equality, what a person can and can't do. So this awareness by public leads to a lot of caution. They have all information on the fingertips, including what would be the burden or the duty by a medical professional when they seek treatment with them. And that is the reason why this entire trend has moved towards this doctor-patient relationship. It has moved quite drastically if we were to compare 20, 30 years ago. All right, 20, 30 years ago, when we see doctors, we are normally under advisement and guidance of doctors. Whatever the doctors may say will be the best advice for us, and we will not basically argue or question the methods dictated by that particular doctor. But now things have changed, and the law has moved in very deeply rooted as to this relationship because of many cases that arise on a daily basis in court in relation to medical negligence. All right. Now, the entire duty will start when a patient is referred to a doctor. There will be no duty if there is no patient. That is very logical. And now this duty in law is known as a duty of care. And to failure to carry this duty, legally we say it will give rise to what we call a tortious liability. Now, if I move along very quickly, I'm not going to bore you with the legal jargon too much. This will be the simple formula. When a patient comes and sees a doctor, inevitably or impliedly, there is already a duty of care. As soon as you have attended, there is this duty. It is innate, it is created at that point of time. Now, if there is a breach of that duty, meaning that the doctor had done something wrong or something negligent or misadvised or misinformed, then the doctor has caused it. And it is not too remote, it is foreseeable that will create to what we call a tortious liability. Now, this tortious liability is the crux of any problem in the court, whether how liable the doctor is to be held or not. In layman's term, very simply, it purely says the doctor to exercise a reasonable care and skill towards his patient. That is all is needed. Now, as early as 1925, in the case of Bateman, right? And someone comes and consults that profession, he means the profession of the patient to use diligence the treatment. That is all is needed. So since 1925, the case laws have opened up a trend. What is duty that you have? You possess that and you dispense with it. And that is where that particular duty is said to be discharged. All right. And this duty, ladies and gentlemen, is an extremely heavy one. You are shouldering a massive burden onto your shoulders when you discharge this duty. Now, the next question is that why does the law impose such a duty on the medical profession? Why medical profession? What's so special about this profession? Bottom line, clear-cut answer, doctors deal with life and death situations. All right. Every single advice, every single medicine prescribed carries a burden onto you that the patient does not have any side effects or suffers or goes beyond that problem. Okay. Therefore, the duty onto or imposed by law onto doctors is a very heavy one. And that is a reason from time the development of the law has moved along. If I were to tell you, at a rapid pace, they come to this issue of consent. Now, for laypersons, as we can look at this chart, yeah, it's very simple. We have just made it very easy for you to understand. What is consent? For layperson, it's an everyday word. But for your profession, it has a different connotation or implications because you guys are professionals. That's what the law looks at you, and that is what you are parting with to your patients. Now, in
Hi all, we got technical problem. A moment.
Ladies and gentlemen, I'm sorry, I'm back. I'm so sorry about that little glitch that we encountered. My apologies. Looks like I'm a bit of a bad line here. And I hope it's right. Consent has a very okay. All right. Sorry. Can you hear me? Connection says it's variable. Yeah. It clearly defines consent. Basically, it is just an exercise of good practice and is seen as good manners. At the next page, I have gone through the case as early as 1914, the case of Mary Sheldon. Now, basically it says every human being of adult years of ladies and gentlemen, I think we are experiencing some unfortunate internet connections here in the office. If it goes off again, I need to stop the session for a short while. Maybe I can change the computers, or I will move to a different area where I can get a better reception. Yeah. I'm not sure whether you all are hearing me clear.
Now getting better.
You can, Jazrul. Okay, thank you, Jazrul. Thank you very much. All right. So I will just continue very quickly. If there's any disruptions, I will just give me about 5 minutes. I will do the necessary arrangements to reconnect with another computer. All right. Now I'll come to consequences, right? Taking the judgment from Mary's case earlier, it will be basically if you were to carry on any medical treatment on a person, it will be considered to be a tort of trespass to a person. Meaning, in normal terms, it's a battery against a person. And this offense of battery is a penal code offense in Malaysia, but please do not worry too much about it. What will happen is that normally we have not seen any cases where doctors are taken to task in a criminal court for this offense of battery. Yeah. So bottom line, what you need to understand is that if a doctor were to exercise any form of treatment onto a patient without a proper consent, you are committing an act of trespass. That's all the law says. Now, moving on to consent, we do have multiple definitions of consent. Yeah. Now, if we were to look at item number 8 of the Malaysian Medical Council's guideline, they have given us a list of comprehensive annotations of what consents are, the different mode of consent. Now, for us, they may be used interchangeably, but it can be seen under implied, express, or as per our topic of discussion this afternoon, informed consent. As I've said, they tend to overlap. Now, implied would be, it's not expressed, but some form of gestures were given by the patient for you to take it, or the doctor to take it that, yes, he had consented. Now, there are lots of pros and cons onto this. Express can be oral, written, and clearly stated by the patient. But is it sufficient? Then we have the informed consent. This informed consent has very much legal meaning to it. It must be as clear as possible as to the ramifications. And as we go along, I will be able to show you what it entails. Now, based on this consent is not automatic. It means that you have to gauge the capacity of the patient. Now, some patients don't have that capacity. It means that they are not by law regarded as an adult. Therefore, you must figure out why and under what circumstances that particular patient is categorized. What kind of consent can I obtain? Can it be in a form? Can it be in writing? Could it be purely via gestures, or it must be verbal? All right. All this has to boil down to one particular area. Is that sufficient for you to make up your mind that that becomes an informed consent? Therefore, we have to go back to the earlier discussion of capacity. Now, capacity is, as I've said earlier, explained in the Malaysian Medical Council guidelines. Normally, we know the Age of Majority Act 1971. For those who are new to these areas of law, you can just have a quick look out and look and see what is the Age of Majority Act 1971. And you just look at whether they're 18 years and above, and also look at whether what is their status is. Now, for example, I've given a simple write-up on the screen. If a patient is a minor below 18 years, now is a guardian. The law recognizes the guardian, and a parent is defined under the Mental Health Act. Not to say the parent is mentally unsound, but there is a definition per se under the Act. Then let's say the second category, patients who are impaired or handicapped. Now you would refer the next of kin, legal guardian. Then you have to obtain the consent from them. So if you're looking at all this, all right, be very, very careful. Please be very careful, because you may be at haste or in haste getting the consent, but not realizing the person that who's before you will not be the person who is entitled by law to give consent. So if this scenario happens to you in the near future, which I hope it won't, but if it does, be extremely careful how this consent for these situations are obtained. Be extremely wary, yeah, because this will be opening up a can of worms later if this matter is taken to court for any reasons whatsoever under the guise of medical negligence. Now, taking this as a whole, ladies and gentlemen, you have caveats imposed by law where it's, next page, is emergencies. Now, in emergencies, the law recognizes that you don't need to have such consents. Emergency, all right. Here, if the doctor personally, subjectively feels there is an emergency, you need, or the patient needs immediate and urgent treatment purely to save life, then you can carry on that procedure. As I put there, there is also this Regulation 48 of the Private Healthcare Facilities and Services Regulation 2006, but this is more towards private healthcare. But nevertheless, this is an overview of what you can see, what you can accept as a caveat. Now, on top of that, yeah, please refer to the Malaysian Medical Council guidelines. If you can look at para 5, it explains to you in just a little bit what this emergency requirements works as your defense. All right. Now, if you look at para 5, I will just paraphrase very quickly. It says that a consensus of the primary surgeon or physician who is managing the patient and a second registered practitioner is obtained, and the primary surgeon or physician signs a statement with the consent form stating the delay is likely to endanger the life of the patient, the second medical practitioner must co-sign the consent form. So even under emergency situations, you must have a seconder. That shows that how critical it is that the medical profession have to ensure that you are doing it right by law and by having a corroborative person to show that that particular surgery treatment is necessary because of cases of emergency. So it must be exercised under strict circumstances. All right. And if I can take you to the next page, there is this case of West Berkshire Health Authorities in 1989. The court did say in that case, if it is a treatment to save lives and is the best interest of the patient, the doctor can do so. So there is a caveat. Now, based on this background of what I have narrated, ladies and gentlemen, we will just touch on the crux of our conversation today. That would be informed consent. But yeah, I'm not getting anything. Informed consent. Yeah. Now, whatever said and done, the premise of this subject matter is the meaning of what is the law that recognizes informed consent to be. All right. Now, there are many definitions of consent. For example, again, I have to refer to your main guide. That would be the Malaysian Medical Council guidelines. If you've managed to get, I have a copy of it. If you want to, I can share with you, Azrul and the team later. Now, if this particular consent, as stated by your medical council guideline, it says that a very clear-cut definition, unambiguous. Informed consent can be said to have been given based upon a clear appreciation and understanding of the facts, implication, and future consequences of an action.
No, sorry for interrupting.
Yes, Yazrul.
The screen, we're having problem with the screen on the PowerPoint slide here.
Oh, Yazrul, may I know at which part that you're stuck?
Maybe I can share from my side.
If you can, sir, that'll be brilliant. If you can, that'll be really, really great. I'll be really grateful.
Let me try first. Maybe you have to stop the screen sharing.
Okay. Okay, it's done, Yazrul.
Right.
Got so many problems today.
Can you see the screen?
Yes, Yazrul, I can see the screen. So we have just gone to part H. We are at the D now. We have to go to H, sir.
H, eh?
H, yes, H for Hong Kong.
Right.
H for Hong Kong. We have gone to G, yeah, H. So we are going to informed consent. So I've covered up informed consent, and then I'm going to the next page. Yeah, this is where it is. And then I've gone to the example. I'm quoting para 8 of the next page, 8C. Yes, this is the one, sir. 8C of the MMC of what is said to be the informed consent. Yeah. Now, I've read, ladies and gentlemen, this is from the Malaysian Medical Council guidelines. What basically it says is that it's a medical legal requirement or procedure. What the doctor must ensure is the patient's knowledge of all the risk involved and the cost involved in the treatment. What the doctor is incumbent to do is to inform the patient the nature of the proposed procedure, surgery, treatment, or examination, or is there any alternative treatments, and most importantly, the potential risk and benefits of the treatment. Now, this can be as clear-cut as day. Kindly ensure this requisite definition is followed by all doctors when you are dealing with patients. There are no shortcuts to this. This is mandated by law. Yeah. Now, the next is that I'm sure that most of you all are familiar with Professor Kula in his write-up called Laws Governing Clinical Practice in Malaysia. He kind of made it into a gist that whatever the doctor is prescribing, it could be advice, it could be treatment, it could be diagnosis. Please make sure it is understood or adequately understood by the patient. That is all you must ensure. Now, later we have this article, Informed Consent, a Socio-Legal Study. The writer also clearly emphasizes the explicit agreement made by the doctor is competent. All right, is adequate information, is intelligent, and it is subject to deliberation by the patient to make that particular choice. And he agrees to that mode of action. If that is met, the informed consent definition is met. So that is how the law recognizes it. Now, I am going to touch on case laws. The reason why this informed consent can be translated into case laws or can be seen more clearly through case laws is what lawyers do. You cannot give a talk, unfortunately, ladies and gentlemen, without referring to case laws, where these case laws forms the crux of understanding how the courts do dictate the facts of the case and how they dictate the findings. That's the reason why this topic is very related or interrelated with case laws, which you will be seeing as we go along. The first case, I would like to say the principle of informed consent. This is as late as 2015, surprisingly, in UK. We had the case of Montgomery was Lanarkshire Health Board. Now, I won't go too much into detail of this case, but maybe later as I go along towards the facts of the case later. What the courts recognized in UK is that the duty to advise of material risk. It is the doctor's duty to make sure that this has been parted very clearly to the patient. And there must be from the patient an informed decision. So the law has evolved that at one point of time, the doctor tells the patient what's best for him. Now it's insufficient. Now, not only the doctor advises, not only the doctor makes it very clear, it must also come with the added baggage of explaining in detail all the risk that comes along with it, as what was clearly stated in the guidelines, the Malaysian Medical Council guidelines, para 8C, which is extremely clear. Now, those days, we have these forms. Patient signs the form. That is insufficient now. All right. So what you need to do is that the time, the patience taken by the professional to advise the patient what can be and what can't be done, what are the procedures, what are the material risks, what are the costs involved until to the end. So you see the duty has encapsulated widely to you. Therefore, it is not only about treating a patient. There are much more that comes together with it, which you have to undertake because that is your profession. All right. Now, in relation to this particular talk, ladies and gentlemen, I am going to break it up only to advice to patients. All right. We are not going to talk about diagnosis and treatment because that is a different topic for another day. Hopefully, if we meet again, yeah, which I hope we would. But nevertheless, this is only in relation to advice given because there are so much of inroads that has gone through on this area, in this area. Now, you may be asking before I start looking at this case law so that I can give you an idea of what the law is like in regard to consent. Those days, it is under one umbrella. Your advice, your explanation, your treatment, your diagnosis, everything comes under one umbrella. Now, the courts have sieved them to different areas. That's the reason why you need to know what these case laws say and what on how you can be alert or alert yourself hey, listen, now we are in 2021, moving towards 2022. There's so much of movement in the law. There's so much of development. Now, I may not exercise what I've said to a patient 5 years ago. Things have changed. So you will be seeing as we go along, both Commonwealth cases, especially the UK cases, which we are bound by, not bound by, I stand corrected, that we will be using as persuasive authorities, and our Malaysian cases, which are more towards the fact that we are bound by the Malaysian cases. Now, as I mentioned earlier, all right, just the next page, please, as to the medical practitioners, right? Now, why are we so concerned about all this, or even this talk? Bottom line, you don't want to be sued. That is all the issue is. All right. Now, how not to be sued? Why a patient undertakes to sue a doctor for medical negligence? Now, there is no specific answer. If that happens, it will happen. You can't stop it. But if you have undertaken your duty of care, like what I've explained at the very early of this talk, that tortious liability, the duty of care, you have undertaken the duty of care as what I've explained until the last couple of minutes. And if you're undertaken and everything is on paper and everything has been meticulously followed, it will be very difficult to hold the doctor for medical negligence. That I assure you, because that is what the law looks into. All right. Now, as I've said earlier, ladies and gentlemen, I am going to take a few important cases as live issues, so that it'll be easier for all our esteemed participants to understand. This case law gives a great idea, a wonderful idea as to the progression of law from 1950s, 60s, 70s, 80s, all the way through to current position. Yeah, they will shed some light as to how the courts confront these issues, how a doctor is supposed to confront the patients in the lens of the judicial body. And more importantly, what's important is that how the court will look whether a particular doctor has discharged his proper duty of care towards the patient. What standard is expected of you as a professional? Now, may I just start the mother of all cases, the Bolum versus Free Hospitals. It's a 1957 case, which is known as a Bolum test. Now, this particular case is a guide to our courts as late as 2007. I'm not saying that we have departed from that particular case, but as we go along, I will tell you why. All right. Now, this case is a bit interesting. The patient was a voluntary patient at a mental health institution. He went there to volunteer himself for some therapy. He agreed to undergo this electroconvulsive therapy. All right. He was not given any muscle relaxant. So what the doctor did was that he has put him on a sofa and he had started the therapy using electroconvulsive therapy. What the patient did was that he suffered injuries because it's electroconvulsive, electric running through you. He fell off the sofa while the therapy was in motion. Now, the question was whether the patient should have been given a sedative or he should have been held onto the sofa so that would have broken the fall. What the court said is that, yes, the patient injured himself, but this is a landmark decision by the court. I believe the House of Lords, they said, a doctor is not guilty or liable of negligence if he had acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. Now, it's beautifully written, meaning you are protected in 1957, ladies and gentlemen, based on this case law. Whatever act that you have done, it is in accordance by an accepted standard or practice by your own peers, that is medical men skilled in that particular art, you are not negligent. That's what it says. Now, it sounds very, very alluring. It sounds very logical, because you cannot put a common man to dictate your standards. It must be men who are specially skilled in your own area. That's the reason why we call each other our peers. So based on that, if your peer says that, listen, what the doctor did was right in our medical profession, then the court will look at that and say there is no negligence. So this is more towards what we call the doctor knows best principle. Now, if this is done, you are protected. Now, as we move along, in 1985, we have another case called Sidaway. All right. Now, Sidaway is a sad case. All right. What happened was that the patient suffered pain in her neck, her right shoulder, and also her arms. The doctor, a neurosurgeon, he obtained consent for cervical cord decompression. All right. I am not quite familiar what it entails, but it sounds extremely serious in nature when someone conducts a cervical cord decompression. This procedure was not explained to the patient. Further, it was not explained to the patient, and this is a crux, ladies and gentlemen, yeah, that less than 1% of such cases, the procedure can cause paraplegia. That, as you know, what paraplegia is, basically a paralysis of the lower part of the body. In this particular case, the procedure was done. The patient suffered paraplegia, spine injuries. All right. Now, the patient's case is very simple. If the doctor have informed me the risk inherent on the operation, the patient would not have consented to the said operation. Now, just imagine, I've given these two cases as a prime example. If you were the doctor attending the patient, what would you do? It's a subjective test. But in this case, the majority of the judges in the courts use the Bolum test. That is, doctor knows best. A group of doctors, your peers, say that it was right, that will be sufficient. But this is the starting point where the courts took a different view. Even though the majority, I mentioned majority because normally there could be 5 judges sitting on the day or 3 judges sitting on the day. 2 or 4 have decided in favor of the Bolum test, your peers test, doctors knows best test. That is the majority. But Lord Scarman is a distinguished judge. And we are still reading his judgment still today, the legal profession, I mean. In dissenting, he opposed that view. That was the very first time since Bolum, ladies and gentlemen, that a law lord or a judge has dissented. What Lord Scarman said is this. In a beautifully written judgment, he said, the law must recognize a duty of the doctor to warn his patient of the risk inherent in the treatment which he is proposing, and especially so if the treatment be surgery. The critical limitation is that the duty is confined to material risk. The test of materiality is whether, in the circumstances of the particular case, the court is satisfied that a reasonable person in the patient's position would be likely to attach significance to the risk. If, therefore, the failure to warn a patient of the risk inherent in the operation which is recommended does constitute a failure to respect the patient's right to make his own decision, I can see no reason in principle why the risk materializes and injury or damage is caused. The law should not recognize and enforce a right of the patient to compensation by way of damages. This is the very first time that we saw a dissenting judgment which says that no, the doctors cannot go scot-free if they did not explain in detail the procedure, the consent the procedure all has to be explained. But of course, Lord Scarman was in the minority. The Bolum test prevailed. In the same year, ladies and gentlemen, we have the case of Montgomery, which I referred earlier. All right, this case completely adopted the dissenting judgment of Lord Scarman. All right, in this particular case, the facts of Montgomery, if we can see the following page, it basically is that this patient was short-statured. She was an insulin-dependent diabetic during her pregnancy. Okay, these two conditions above, being short-statured and the insulin-dependent, can cause the baby to have shoulder dystocia. All right, during delivery. The baby suffered this birth trauma and later developed cerebral and Erb's palsy. The patient sued the obstetrician, the doctor, simply because the doctor failed to discuss the possibility of birth trauma if she had a vaginal delivery. Now, the question is this: should the doctor have informed the patient of the risk of shoulder dystocia at delivery? That was the question. All right. Now, what the Supreme Court in UK held is this, and this is applicable to today, ladies and gentlemen, and is applicable to your profession. The court said an adult person of sound mind is entitled to decide which, if any, of the available forms of treatment to undergo, and her consent must be obtained before treatment. All right. The doctor is therefore under duty to take reasonable care and ensure, this is where it comes in, that the patient is aware of any material risk involved in any recommended treatment and of any reasonable alternative or variant treatment. The test of materiality is whether, in the circumstances of a particular case, a reasonable person in the patient's position would likely to attach significance to the risk, or the doctor should reasonably be aware that the particular patient would likely to attach significance to it. Yes, I do understand it's a bit of a legal jargon. Basically, what the Supreme Court said is this: you explain. Make sure it's clear. Make sure the patient knows of the risks. Make sure very clearly, very, very clearly, that consent is given before you proceed further. Now, on the next page, this is what the court said. There is something unreal about placing the onus of asking on a patient who may not know that there is anything to ask about, which is true. Most patients, if I were to be a patient, ladies and gentlemen, if I have a condition, I wouldn't know. I don't even know what to ask about. Therefore, the court followed. It is indeed a reversal of logic. The more the patient knows about the risk she faces, is easier it is for her to ask specific questions about those risks, so as to impose on a doctor a duty to provide information. But it is those who lack such knowledge and who are in consequence unable to pose such questions and instead express their anxiety in more general terms who are the greatest need of information. Now, you see what the judgment says? Your duty is not only to provide that information. Patients know zero. We know nothing of the problem that we are facing because we are not professionals. If we know, it makes your life easier, but we do not know. Therefore, what do? You explain so that I'm informed, so that when I give my consent to you, it becomes an informed consent. Simple as that. Yeah. Now, in Montgomery cases, you can see how the court has arrived to this conclusion. All right. You must inform in great detail. Yes, it's a balancing act. You may be very busy on the day. Too bad. The law doesn't recognize that you're busy. It recognizes that you've discharged your duties. And that is where the rub lies. You have to be very, very careful, because this is a life and death or being crippled forever situation. Therefore, the best formula to follow is very simple, ladies and gentlemen. Be patient, with your patient. Make sure they understand that the sequence or the responsibility that affects their life, the burden is on you to discharge that duty. Yeah. Now, carrying on with that, we have in 1992 the case of Roger versus Whitaker. Now, this is also a very, very important case because it has affected Malaysian cases. Now, this is an Australian case. This case gives the opposite directive as opposed to the Bolum test. Bolum test, remember, doctor knows best. Roger's test is patient-oriented principle, that it must be an advice towards patient orientation. All right. Now, in this case, is that the patient was almost completely blind on her right eye. She consulted the patient's ophthalmologist, I think the ophthalmic surgeon, who advised the patient. This is what the doctor's advice was. It was very good to operate the eye. You will get better improvement, not only in appearance, but also a restoration of sight. That's what the doctor said. Now, after the operation, very unfortunately, it went downhill. There was no improvement on the operated eye, whereas the other eye developed an inflammation, and which led to loss of sight. This condition is called a sympathetic ophthalmia. Therefore, the patient sued. Now, the High Court went in detail of the doctor's duty, and this is in the Australian standards. That is, the doctor here clearly failed to advise and warn the patient of the risk inherent in the operation. And directly, what happened was that this failure led to a breach of duty. Now, there is the judgment. I'm not going to go into it. It's basically, that's what this whole thing is, that the doctor failed to exercise reasonable care and skill in the professional advice and treatment as a single comprehensive duty. If you have time, you can read the case to have a better understanding how the court derived. It's a bit complex, but it's a very, very interesting case. All right. These are the cases in UK and Australia which have direct implication to Malaysian law. Now, Malaysian test has always been the Bolum principle. All right. This is what the standard of care the courts have exercised. But in 1992, after Rogers, Malaysian courts have began to take another look at this standard. Because sometimes you look at this, if you were to take only the professional standard of a group of men who are skilled in their profession as seen as be an art, they can never be right. Why do we always have to subscribe the doctor knows best test? Why can't it be the patient's orientation? Why can it benefit the patient? Therefore, the patient-orientated principle grew in Malaysia. And that's the reason why some of the courts did not want to follow Bolum. They preferred Rogers. But despite this two set of principles used in Malaysia, Bolum seemed to be the preference until 2007. Now, this is something that most of you all would have heard, known. If you have not heard of this case, try to look into it. This is a federal court case in 2007. It's a very, very seminal case. It is salutary to know what this case is all about, because this is the case that started the flow of other cases in the legal profession. All right, now, this is a case of Fu Fiona, was a Dr. Su Fuk Man in 2007. Now, again, I have to make it very clear. This talk this afternoon, ladies and gentlemen, is only in relation to doctors providing advice to patients. It has nothing to do with treatment and diagnosis. Yeah, as I said, it's for another day if it comes to that. Now, this case, Fu Fiona, changed the entire landscape of what is the duty of care when doctor is advising a patient in our Malaysian context. All right. And what is known as an informed consent. Now, in this case, it is a very, very, shall we say, unfortunate case. The patient, Fiona, was involved in a motor vehicle accident and she suffered injuries. Her injuries, amongst others, were the close dislocation of C4 and C5 vertebrae. The doctor was an orthopedic surgeon who was on duty on the day who treated the patient. Now, the patient underwent 3 surgeries to the dislocated cervical vertebrae so that they can be put back into their original position. This involved what they call as an open reduction, where the nape of the patient's neck was surgically opened and the dislocated vertebrae moved to their normal position and secured by bone grafting and insertion of a loop wire to stabilize the spinal cord. The patient became paralyzed after the operation. What the doctor did, he managed to carry out a second operation to remove the wire because those wires could be the main problem for the paralysis. But most unfortunate, the patient remained paralyzed. Now in court, there was evidence that showed that the loop wire, which was placed to correct the dislocation of C4 and C5, during the very first operation was pressuring the spinal cord. And that was a cause of the total paralysis. Now the question was whether the doctor was under a duty to advise the patient on the course of treatment to be undertaken and the risk involved in that procedure. Was there a breach of duty of care? Now the doctor is saying, listen, irrespective whatever I do, the paralysis is caused by the accident. And if I don't do anything anyway, the patient will be paralyzed sooner or later. That was the defense taken in trial. Now, this is where you can't run away from evidence, ladies and gentlemen. Everything is recorded. Now, we go back to the consent issue, the informed consent issue. Do you think you would have done the same under the circumstances of Fiona's case? Maybe one day we can talk about it, because these are life issues. Would you, being in the shoe of your peer, have done the same as what the doctor in Fiona did? In this case, there were 2 express consent forms. We have thousands of consent forms because we are so petrified of being sued. Hospitals have a stack of them. But again, these consent forms will come into question when evidence is led in court. Now, these consent forms in Fiona were her admission. It says that when she was admitted, she gave a consent. But evidence showed that this was not at the time of the contemplated surgery. So how can you give a consent when it was not even put to you by the surgeon? Again, the duty to advise, to explain the surgery. Because mind you, ladies and gentlemen, at that time, she was not paralyzed. She was just suffering from the injury and she was in pain. What would you have done? Think about it. The second issue of the consent in this case is that there was a thumbprint on the form bearing the first operation. Sorry, a date after the first operation. Now again, when the person has already become paralyzed, all right, this issue of thumbprint came to question in court because evidence was led that at the time she has lost all sensation to her limbs. Now you see what happens. You have consent forms, which the doctor is saying that it's an informed consent, but yet evidence shows otherwise. Now, this is where the federal court came hard on the issue of medical negligence. What the court did on the next page, ladies and gentlemen, what the court did is this. The court decided But the issue here is not so much on the consent given for the two operations, but on the risk involved and whether the patient was warned of the risk. The patient has given evidence in court that, listen, if I have known about the risk, I would not have readily agreed to undergo the first operation. Now, this is where the conundrum is. You are stuck. What are you going to do under the circumstances? The federal court went on to say, that said, we are of the opinion that the Bolum test has no relevance to duty and standard of care of a medical practitioner in providing advice to a patient on the inherent and material risk of the proposed treatment. The practitioner is duty-bound by law to inform his patient who is capable of understanding and appreciating such information of the risk involved in any proposed treatment so as to enable the patient to make an election to or not to go through with the treatment. That's all. Now, what happened in Malaysia now is this, ladies and gentlemen. When you are giving advice to the patient, even before going on to the next step, before even you get the informed consent, you must inform the patient of the risks attached to the procedure. You must inform the pros and cons. The meeting of minds must be extremely precise and clear, that the patient understands you and you understand the patient. And that advice is not bound by the Bolum test, meaning you are opening up to litigation because you are not observed or treated in the eye of your peers. You are treated in the eye of the court. What you did is right or wrong. Like what the court said, there is a need for members of the medical profession to stand up to the wrongdoings, if any, as the case of professionals in other professions, like mine. In doing so, people involved in medical negligence cases would be able to obtain better professional advice, and the courts would be appraised with evidence that would assist them in their deliberation. And finally, the court made this observation. They said, we are of the view that the Rogers test would be more appropriate and viable in this millennium than the Bolum test. And to borrow the quote from Lord Wolf's inaugural lecture in the New Provost series delivered in London 2001, the phrase "doctor knows best" should now be followed by the qualification words "if he acts reasonably and logically and gets his facts right." Now, it sounds a bit demeaning. No. We all make mistakes. You will make a mistake. It's a matter of time. But you can evade that mistake if you had followed through the advice of the courts, as have been explained to you in detail in this talk. It's a very, very simple approach. It's a common sense approach. Do not take onto yourself that you know better. It doesn't work anymore. Therefore, when you're giving advice, ladies and gentlemen, Rogers is the test in Malaysia, not Bolum. Bolum, you are not judged by your peers. Rogers, you are judged by courts. So, when the evidence is tendered in court for any potential medical negligence cases, the court has the floor. They will take all evidence to see whether your advice was right under the circumstances before you have obtained the so-called informed consent. Now, whatever said and done, these two tests, Bolum and Rogers, remain controversial. All right. Now, logically looking at it, you may, whoever is participating today, all you esteemed doctors, you can make up your own mind because you can relate to the samples I've given earlier, the examples. You can put yourself in that doctor's shoes and say, hey, listen, which test am I going to follow? Am I going to go for the Bolum test or am I going for the Rogers test, which would be a better test? But in Malaysia, based on full Fiona, insofar as advice is concerned, ladies and gentlemen, there is only one test. That is the Rogers test. That is the patient-principled practice. The patient-oriented principle, sorry. So you must be very, very careful in what you want to do. Then we have later on in 2010, the case of Hassan bin Datola versus Kerajaan Malaysia. The ratio or the principles of full Fiona was accepted. And the Court of Appeal in that case decided that the standard of care to be observed by the medical practitioner in a medical negligence suit is actually the Rogers test, not the Bolum test. All right. So the court can gather evidence, because whenever you come to court for a medical negligence suit, it's all evidence-based. Your evidence and evidence of your peers. Now, the court now will have all this evidence before them, and they will decide whether you have committed a breach of duty or not. Therefore, ladies and gentlemen, always remember, Bolum test does not apply to the duty to disclose risk and advising patient. It only applies to duty of diagnose and treat. Whereas for full Fiona in Malaysia, any advice falls under Rogers test. That is, you make sure that the patient knows. You are not governed by your peers anymore. You're under the dictates of the court based on evidence. Yeah. Now, we are coming to the last major case in Malaysia. That's on the next page. Is a Zul Hasnima's case. This was in 2017, and I believe that this is where we are now. All right. Again, the same issue was raised in the federal court. Hey, listen, we all are confused now. Which test are we going to follow? So the courts have answered clearly where Malaysia stands. What you as the medical professionals, medical practitioners have to follow. Now, this is what the facts of Zul Hasnima is this. She was pregnant. She chose the doctor as an obstetrician and gynecologist because the same doctor has delivered her first baby by C-section. All right. Now, into her 36th month of pregnancy, the patient went to the hospital because she was complaining of stomach pains, and she was administered to the hospital, and I believe that she was admitted as well. All right. At the time of admission, ladies and gentlemen, the pulse was high. It read at 108, and blood pressure was 122/68. She was given pethidine and phenergan as ordered by the doctor. There are two medical medicines that were given to her. The pulse came down to 80. Blood pressure was steady at 110/70. Now, later in the morning, the patient collapsed. Result of severe bleeding. The blood pressure could not be recorded. Code blue was ordered. Alarm for emergency. The patient was resuscitated in the ward. She was rushed to the OT for emergency C-section conducted by the doctor. Baby was delivered alive, and hysterectomy to remove the patient's uterus was performed when the doctor carrying on the C-section discovered that the patient had a ruptured blood vessel at the placenta. Now, during the course of hysterectomy, the doctor discovered further that the blood vessel at the fundus or the top of the patient's uterus has ruptured, and therefore the sudden blood loss, bleeding, and collapse of the patient at the ward. The collapse resulted in a sudden and significant loss of oxygen, hypoxia, to the baby, and as a result, the baby suffered severe birth asphyxia, causing the baby suffering cerebral injury. The patient then sued the doctor, naturally. Now, this is what the patient said in court. She said that she was already in labor shortly after admission. why didn't the doctor perform a C-section without delay? If it was done, then my baby would not suffer disability. She further said, the doctor and the staff were negligent because you failed to diagnose me. You should know that I'm in labor. And instead of carrying all the other emergency procedure, the C-section drugs were administered to lessen the pain. The doctor should have foreseen what the patient could have suffered. That is the uterine rupture. And in fact, the doctor delivered the patient's first baby should have known better, because the patient had a condition called cephalopelvic disproportion. And when the patient collapsed, the doctor failed to resuscitate or adequately resuscitate the patient when the code blue alarm was sounded. That was purely the patient's case. The doctor's case was completely in contradictory. She said the bleeding suffered by patient was not caused by the uterine rupture, but the rupture to the blood vessel on her uterus. And the patient had 1 in a million chance known as a placenta percreta, where the placenta, which normally adheres to the inner lining of the uterus, grew through the wall of the organ. The placenta had only grown through, not only had it grown through the organ, but it has come out on the top of a uterus, making the condition virtually undetectable unless a surgical examination was done. There is no issue about delay attending to the patient because she was monitored closely. There was no sign that she has gone into labor. And based on the patient's history, an elective C-section would have been done if she was at 38 weeks gestation, not at 36 weeks. And she was not in labor on top of that. Therefore, the need for emergency CS only arose when the patient collapsed and she lost consciousness. And even then, everything was done within 15 minutes of a collapse, and within 30 minutes, the baby was delivered. And this was in line with the international standards, the accepted standards of the international practice. Now, High Court, Court of Appeal both said doctor is not negligent. And in the federal court, the Court of Appeal has listed down the entire narration of cases from Bolum, Sidaway, Montgomery, Bolito, into Rogers, and way into the Malaysian context. Now, this is what the standard of proof in a medical negligence suit. All right, what the federal court said is that the approach of Bolum test practically meant that while the law imposes a duty of care, the standard of care owed by a doctor to a patient is left to the medical fraternity. That is what we've been saying so far. That is a doctor's knows best principle. Then they went on to the case of Sidaway, which I have explained to you earlier. Then they went on to the case of Rogers. The learned federal court judge went into Rogers. Here they defined 3 different areas which was a point of contention: diagnosis, treatment, or provisions for information or advice. Then what the court said is that, looking at the Rogers test, all right, they accepted and adopted that particular test because when in the issue of diagnosis and treatment, okay, the patient's contribution is limited. The doctor provides the diagnosis and treatment according to his or her level of skills, except for emergency cases or necessity. All medical treatment is preceded by the doctor's choice to undergo. So in other words, you are in control. All right. Whereas the patient consent to treatment may be valid once the patient is informed in broad terms of the nature of the procedure which is intended. So the law recognizes the doctor has a duty to warn the patient. So now you see, not only you tell the patient it can be done, you have a duty to warn the patient of a material risk to the proposed treatment. You can never at times say, don't worry, everything will be hunky-dory. It won't work. He must be told of the material risk. So what the court said is that this has to be explained in detail, meaning that a significance must be attached to it. The patient must know and the doctor must know. But this is subject to what we call a therapeutic privilege. To most of you, I believe you'll understand what is a therapeutic privilege. Yeah, I mean, I've written there. It's basically a defense for law doctors, where they fail to disclose any relevant information, or as to the when seeking informed consent, you don't disclose the full details purely on the belief that if you strongly believe subjectively that whatever that you're going to say or the information that you're going to relay to the patient will cause the patient serious physical or mental harm, then you are bound by the therapeutic privilege. But it is a long shot. There are very rare cases when this comes, because now patients are very well aware of what and what not to do, what or what not to expect. We are smarter. So what the court said, insofar as advice is concerned, now it is for the courts, then a body of respected medical practitioners who will decide whether a patient has been properly advised of the risk associated proposed with the treatment by applying the materiality test. So now, as I've said earlier, the court will have to decide. Then we went on, the federal court also touched on the case of Bolito. Bolito's case is a 1997 case, which is another unfortunate case where Bolito is a 2-year-old, Bolito's case is in relation to a 2-year-old boy who was suffering from respiratory problems, infections. The patient was given a senior nurse, one-to-one basis. He had, during the care, respiratory episodes. The doctor was informed, but the doctor did not attend to the patient. Following the episodes, the child was active, so they never thought much of it. But after the second episode, after half an hour, the boy had a respiratory attack and a cardiac arrest. They revived him. He had brain damage and he died later. He succumbed to his injuries. The mother of the child sued the hospital. What she said is that the doctor should have intubated the patient. Yes, the doctor not coming to check on the patient is a different issue. There was clearly a breach. But the doctor said, irrespective I'm there or not, I would not have intubated the patient. So this is the view of the respectable body of doctors. There is intubation is not necessary. There, the doctor escaped liability because the test was at the time is the group of respected body of persons who are agreeing to your method. But in Bolito's case, the House of Lords qualified that the court finds that the procedure cannot withstand any logical analysis. The court can intervene. Yeah. So if you look at this, ladies and gentlemen, the trend of cases, even Pierce and Norman and another Montgomery, we are coming back to the root of Fu Fiona. We have pre-Fu Fiona and post-Fu Fiona. We have two inconsistent lines. Now, basically, what the court in the federal court said generally is this. They said that in the court's judgment, This is the Malaysian case. Azrul, if you can go back to the next 2 pages, please. The other page as well, the other page as well. And the other, yes, this is the one. This is the federal court's reasoning, which will be a very good read if you have the time. Yeah, these authorities are all relevant for your practice. They say that in our judgment, that in respect of standard of care in medical negligence cases, a distinction must be made between diagnosis and treatment on the one hand and duty to advise of the risk on the other. This is because diagnosis and treatment are purely in the realm of medicine, and that in the field of medicine, there are genuine differences of professional opinion in respect of diagnosis and treatment. I think that we are safe there. All right? Because the court says that that is the domain of the medical profession. All right? Now, whatever said and done, okay, what the court said that the court cannot, in certain matters, equipped to resolve a problem. All right? The court is bound by that group of respectable people, their views, etc., etc. All right? So bottom line, if you are an expert and this is in relation to advice only, the court will interfere. If it is in relation to the treatment per se, the court cannot interfere. So what the court propounded after going through all the cases, Jazrul, can we just go on all the way up the next page as well, please? The following pages too. These are all our judgments. You all can read if you want to. I'm sorry, it's a bit too lengthy because all the test cases are in this. Yes. So we have settled. In Malaysia, the position is settled based on Zul Hasmina. All right. This is the correct test for informed consent. Please be advised, all right, at all times. The law evolves. It will change from time to time. There will be situations which can be very different. Courts may decide on different areas where even this standard may change in the future, right? But when it comes to advice, please remember, I'm going to go back just as an overall precursor to read in general what we have spoken so far. Your duty when you are advising the patient before you obtain the informed consent. Mind you, you may be thinking as of today, the hospital has prepared the informed consent. The patient is given the form. The patient signs the form. My job is done. It's far from it, ladies and gentlemen. You are not far from done. Yeah, your duty goes beyond that. For you to obtain that informed consent, there are prerequisites. There are caveats attached. There are conditions attached. What are the conditions? Like what we have explained earlier, you must tell the patient, this is what your problem is. This is what the potential is. This is what the treatment can do. This is what you can do and what will happen, the outcome of it. If you don't do, what will be the outcome of it? This is what alternatively you have in hand. This is what the costing will be. This is what the procedures I'm going to do. So basically that person does not know what procedures you're talking about. If I were to be me, I would just shake my head saying that, okay, you know better. But the law in Malaysia, taking the common law, UK, taking the Commonwealth law in Australia, we have come to a consensus. Your advice or I'll rephrase, your defense does not lie that the patient had signed the informed consent form. You will be queried in detail if a matter goes to court, how you came by that consent. The patient will just say, I never gave any consent. If I knew, I wouldn't even do it. Look at Fufiona. Look at Rogers. All these cases spells clearly that I am not, the patient says, I wouldn't know. I'm not a medical person. I am ignorant in all this. You sit down, you explain to me. Now, that is where the crux of the matter, ladies and gentlemen, is your duty to do that. And that is where it has become now, you are a doctor-centered or patient-centered. Doctor-centered is being eroded slowly. Is now patient-centered approach would be the best. So looking at all this, I really and truly hope that it has given you an idea. Now, I will come to informed consent a bit later because some of you may have posed some questions, etc., which I will try to deal with it later. Now, we also have now this thing called digital consent. I've gone on the informed consent. Now it's digital consent. Now, what's going to happen, guys? It's common sense. COVID-19 has caused an unforeseen damage to all of us. Unforeseen trauma, unforeseen circumstances. Never in our lives did we ever thought that we'll be going through this. But it has come, it has arrived, it has caused havoc, it is here to stay. Unless we can beat it. We are living in a new normal. Now, this new normal affects me. All right, for the past 1.5 years, it was a very difficult struggle for most professionals in our business, the lawyers. I believe the same for you too. And I sympathize with your profession because I can see what's happening daily, especially during the earlier stage. Inundated with inflow of patients, the risk that you're taking, the frontliners exposed, not seeing your loved ones, dealing with fear every single day that I may not go back home alive. I will be part of the patient's diagnosis. I may be a patient myself, something that we never saw. So going to the hospitals for treatment is never the same. So patients are scared of coming physically to meet a doctor because of the fear of the virus. So now, what are the other methods that we can introduce that the medical profession can take to the homes of the patient? Now, of course, there is a qualification. Not all patients have this form of flexibility. Sometimes, you'll find that some patients, you can't deal with them using this kind of option. There must be more towards a physical attachment. But here is for those where you are able to deliver medical care to their homes. All right. Now, what can be done? This normally happens to general practitioners, family doctors, etc., etc. They employ this kind of methods, all right, to ensure that the patient continues receiving their medical care. All right, and this is what we call a virtual or digital consultation. All right, in Malaysia, I'm not sure whether you are aware of this. We have this thing called telemedicine, all right, wherein medicine or medical services are provided or is provided remotely via information and communication technology. All right, you do not have to interact physically with the patient anymore. In Malaysia, our wonderful parliament since 1997 had enacted this act called Telemedicine Act 1997. But unfortunately, till today, it was not or never implemented. Even it was passed, it was not implemented. But looking at this act as a whole, it actually works under current COVID-19 situation. All right, there are benefits to it. All right, for it to tackle what we call the new normal. Now, this particular act, in a nutshell, it provides for patients to seek medical treatment without having to leave their home. That's what it says. All right, so I can get, as a patient, access of a doctor from the comfort of my own home. I will not fear for any virus transmission or transmissions. I will not fear putting my foot onto the doorstep of a hospital. But nevertheless, like any other scenarios, everything has its own limitations, ladies and gentlemen. Now, this is where the question is, what platform is this? Now, is it really only for an advice given on the wellness of a patient, or is a form of medical service? We wouldn't know because this is not tested. Would you be able to adhere the principles of privacy and confidentiality? That's one question asked. Who has the duty to maintain the patient's information in confidence? Mind you, we have the PDPA, Personal Data Protection Act. You can't flaunt it. All right. Since this act is yet or not implemented, even doctors are not aware or familiar with this. Even lawyers can't advise because we are not familiar with it because it's not implemented. There is no guideline. There is no what to do, what not to do. But fortunately, again, you can fall back on what we call the Malaysian Medical Council guidelines. They are basically, they have attempted to tackle this area. So one of the proposals that they formed is for doctors to undergo training, or nurses or practitioners to undergo training. They also have to undergo what we call that the ethical and the legal position in relation to the informed consent. So you need to know, even before you embark on this avenue, you need to know what is informed consent in the sense of legal position and the ethical position. All right. Now, on top of that, you must always maintain the patient's confidentiality. Now, if you're using a particular platform, like just now, I was talking to you, ladies and gentlemen, suddenly I lost you for about 10 minutes there. Now, it's not within my power to do so because I'm dependent on the service provider. Now, this platform doesn't work. What happens? Sometimes, if I am telling you or the patient something over the internet or online platform, the patient may not be hearing me carefully because their line is bad. And for all we know, you're saying just go and buy Panadol. That patient may hear something else, another story, another prescription. Then what happens? You see, all these are something to think about. So whatever said and done, ladies and gentlemen, this informed consent must be carefully guarded, carefully monitored, and carefully departed to the other side so that the other side understand. All right. When this, and also mind you, the same thing applies like what happened, the full disclosure of information, whether the patient knows of the risk he's taking, the patient knows what adequate information was given. All these are part and parcel of things that you need to ascertain. All right. So not only you telling A to the patient actually understand that A that you're passing on to the other side. So this is where you really have to go. Azrul, can we go to the next page as well, sir? Sorry. And the other one as well, sorry. Yes. All right. And the other page as well. The other page, the next page, sir. The other next page as well. Yeah, this is one. Yeah, sorry. All right. So in a rational way, as a summary, can we say summary? All right. This is what the doctor's duty. You must ensure the patient understands A to F. Right? And this is something that you must, in your position, have to ascertain. Can I get this done? All right. And once you have done all this, you have handled all these questions or all these issues, the decision must be made by the patient. Do not make a decision for the patient. Of course, I think you know that better than I do. All right. Then, okay, the next page, please. The next page as well. Thank you. And also, the audio video recording must also be done in the patient's consent. So, coming back to this Telemedicine Act, you have quite a lot, meaning that a lot to deal with. But unfortunately, I think that because the government's reluctance to implement it, we are still in the dark. We do not know. All right. Now, I have covered, ladies and gentlemen, quite a vast area. Now, I'm going to come to the conclusion. All right. Yes. The question posed is informed consent. Is it an ethical obligation or legal obligation? Now, I will not be able to dictate that answer to you because you will be the best to know what it is. What I would submit very humbly is that it's both. Why it's both? Because it is my view. It is an ethical obligation because of the profession that you have chosen. You are in the medical profession. As the legal profession, you have an ethical obligation to discharge your duties towards your patient. This is the oath that you have taken when you set foot in this profession. Once you have done so, an automatic duty is imposed onto you, whether you like it or not. This is a duty where we call a legal duty. Now, what is this legal duty? It comes hand in glove. What you are parting to your patient in relation to her or his health problem. Now, based on this one advice to that patient, your duty starts, and you will be shouldering this duty until the patient leaves. The patient, when you advise, must understand you, must understand the consequences, must able to accept it. Clear. And he gives you that consent, which automatically, ladies and gentlemen, translates to a informed consent. Therefore, these are the workings of both ethical and a legal duty. You cannot separate them. Now, that legal duty that you have, based on the development of the law, based on the number of lawsuits in our local courts, international courts, medical malpractices, medical negligence, this has evolved into a legal compulsion. You know why? Because hospitals, doctors, you guys are really, really at the edge to be sued. So when a patient sues on a regular basis for any negligence, because they can do that if they want to, all right, we have the administrators in a hospital asking lawyers, coming up with a flurry of documents to be executed, which will be guised as a consent forms to overcome this liability. It won't work. In reality, you can be as watertight as possible. It won't work. It will only help. I will tell you why it won't work is because you are extremely cautious. But the human fallibility is that you cannot cover all angles. Now, based on this, that is the reason why we are saying that these two issues that was posed in our topic of conversation, whether it's an ethical obligation or a legal obligation, they cannot be separated. Now, based on the above, ladies and gentlemen, my advice, if I may part with that little advice that I can, always use the common sense approach. When you're dealing with your patients, you know your rights. The patient knows his rights or her rights. Your rights and duties come with the profession. Dispense them professionally. That is all the law requires from you, which is your duty. And that is what the law says. Therefore, I humbly thank you for your time, your patience. I thank the team and all participants for giving me this opportunity, which I am truly humbled. And I hope that this particular brief talk had given some insights of what the law is looking for, what informed consent is all about. Again, it's not a piece of paper. It is your human touch. informing to the patient what and what not he can do before even you get his consent. With that, I thank you again. I wish all of you the best of luck under these difficult circumstances. Stay safe and stay healthy. Thank you so much. Jazrul,
Thank you, Mr. Rao.
you're most welcome, sir.
We have, I think, a few questions posted. I think we can, open up for our participant. All the doctors and specialists are here to ask anything pertaining to our topic today to our presenter, Mr. Rao. So based on oh, Mr. Rao, you are on mute.
Everyone, Jazrul, can you hear me, sir? Everybody?
Okay, yes, great. We have a question posted, I think, on the chat box.
Yes, I can check. Can I go one by one as much as I can assist?
Sure.
Yeah.
Please go ahead.
All right. The first question was posed from Shah to everybody. Hi, Shah. Good evening. I hope that I would be able to assist. But looking at the question says, must the consent be taken by the surgeon or a medical officer? House officer can take the consent on behalf of the surgeon. All right. This is it, right? Now, I will only tell you based on the guidelines. If you are the medical officer, you can take the consent. Okay, taking the consent is this: who is the doctor treating the patient? If the doctor treating the patient has the necessary knowledge to part that advice to the patient, I will definitely advise that would be the point person. Do not delegate that consent to others, because mind you, the law recognizes that advice must come from the person, not a delegate. It must be coming directly from the person who's dealing with the patient, either the surgeon who is going to do the treatment or the doctor who's going to advise on the treatment, them. Here, the house officer can take the consent on behalf of the surgeon. I recommend not to, because there could be a legal question later, because the patient will say somebody else came and got the consent, but the consent was not taken by the doctor or the surgeon. So I think that for the form of consent, it will be best if it can be handled by one-to-one. The other people can be next to them, that won't be a problem, but the person who's parting that advice must be seen to have given the advice, and the informed consent was given by the patient to that very person. So that's the first one. That's my view. The question number two is that how long is the validity of a consent? Can it be taken by a surgeon in a clinic prior to admission, or it must be taken once a patient is admitted? But okay, this is it. This is something that has not been decided in court. I have not come across. It may have, but I have not come across it. The best is this: when are you as the medical officer will be informing the patient of what treatment to take before he takes the treatment? Is it at the point of seeing the patient in your room, or once the patient is admitted? Now, the point would be when the patient is told of the condition. Would the patient know of his condition before admission or after admission? I am not quite very sure of that, right? So I would decide that normally, the normal course of events, if a patient goes to the hospital and sees a medical officer, and if the medical officer is unable to deal with the patient, all right, what will happen is that that particular patient will be referred to a surgeon. Now, the surgeon may differ in opinion of treatment based on what the surgeon says. So I believe that it must be at the point of admission, because that is where the doctors will find out more about the patient's consent condition before the patient is told of his problem. So I would say logically it will be upon admission, because prior to admission, it'll be hard. You won't have all the results of tests to show what is the patient's exact condition. So this is how I perceive it should be done. Yep. The next question would be from Yang Mulia. Okay. Yep. Yang Mulia Raja Badrul here. He said, how long does SUSMAC wants it to be? Some facilities say signed informed consent forms are valid for 30 days or the duration of the patient's hospital stay. Other states that the patient informed consent is active until a patient revokes or the patient condition changes. But as what Mr. Rao has said, it is not about the form or document. Informed consent is more, yes, of a process. Now, these protocols of administration, they are not within my purview or knowledge. What we as lawyers do based on evidence, like what Yang Mulia Raja Badul said, is a process. All right, basically how this informed consent is seen to be valid in law. What is your duty to do so? Now, whether they have a cut of a time frame of 30 days or not, I am really not sure, because even your Malaysian Medical Council guidelines don't say it. Maybe they are an internal part of the hospital administration, I wouldn't know. But as far as I know, logically, common sense dictates, if the patient has an issue and if the doctor says, listen, he has to be treated, before he could be treated, there will be advice, the mode of how to treat. When you pass on that information at any point of time and the patient agrees to that treatment, after relaying the pros and cons, the medication, the costs, alternatives, and the patient says, okay, proceed, then you can sign. So I don't understand the 30 days time frame, whether the validity of consent, because I don't see these consent forms have a time frame or limitation. As long as the patient has been told, he signs a consent form, it becomes a process, like Yang Mulia Raja Badul says. Now, and from K. Lee to everyone, he says that, dear sir, what is your view in the event that another doctor pronounced date to the patient and different doctors signed up all the legal forms? All right, now, this is not within my purview, Kelly, because this is not treatment. This is the doctor pronounced the patient to have died and a different doctor signed up all the legal forms. So I'm not sure which angle you're coming from. Are you talking about the legality of these forms? I'm sorry that this is not informed consent area, and I will not be able to give much advice on that, because I may have, or I may be misleading you. I am not quite sure on that area. I apologize. Yeah. Jazrul, I think that those are the only questions posed at the moment. Yeah, there's one new message coming in.
Or we may, open Q&A session lah.
Yeah, and if anybody, in relation to what we have spoken today, if anybody has any queries or any questions, irrespective, don't worry about how good or how bad. If you have something in your mind that I can assist, please just let me know.
Mr. Rao.
Yes.
It's Dr. Sophie again, hospital.
Yes, good evening, sir.
Okay, just want to ask you with regards to when you counsel the patient in terms of the risk.
Okay.
I'm a neurosurgeon.
Yes, sir.
So basically, how detailed do you have to explain to the patient in terms the risk that involved with the procedures? Because when you involve with brain, even a small tiny operation can become a major disaster.
Very true, sir. I totally agree with you, sir. That is the common complaints by doctors who are surgeons and respected surgeons in their specific fields. Now, this is it. What the law says is very simple. It does not impose a duty on you to tell everything. What it tells is that even the patient has a 1% risk of paralysis, it must be informed. It is, so we are looking at a 1% barrier. So there is no plus points or negative points or pros or cons of how detailed a surgeon should be informing the client, but he has to inform the client, listen, if I were to do this surgery, this is the only option that you have at the moment. Number one, you can take it or you don't want to take it. That's number one. Number two, now I'm going to tell you the risks. The risk could be paralysis. The risk could be no paralysis. Number two. Number three, this is a mode of the treatment that I'm going to exercise upon you. Now, after saying all this, sir, the patient says, carry on. It means that you have discharged your legal bounden duty. The court will not question you why you did not go more in detail to explain everything, because these patients are not medical practitioners, most of them. They will leave it to the doctor to their best ability to advise. But most cases that comes to court is when something goes wrong. They will blame the doctor, that you did not say that to me. That is the reason why always when a doctor is giving advice to the patient, a video recording will be extremely helpful. Writing will be helpful. Corroborative evidence, having your peers behind you who may be joining you in the procedure, will be helpful. And the law tells now, based on the current situation, is that the patient should be informed. How much of information is related to you? You don't have to tell, I'm going to use this medication, I'm going to use this medication, I'm going to put you to this kind of anesthetics. Not that. It's only the significant risk, whether the patient attaches the risk to himself. So that 1% would be the marking, sir, the demarcation.
Yeah, the other question, if I may, Mr. Rao.
Yes, sir.
This is the real patient that we are having. Basically, this patient passed away already.
Okay.
She has I think 8 children.
All right, sir.
So when the consent was taken, it was taken from one of the children.
Okay, sir.
But during the treatment, something happened. Eventually, the patient passed away.
Okay.
So the remaining children were not satisfied because the consent was not taken from them.
Yeah.
So where do we go from here? I mean,
okay, sir. This is where the legal conundrum comes in. If that one person that who has given the consent on behalf of the patient falls under the Age of Majority Act, falls under the Rationale Act, that he can consent to it, and proof to show that the patient has given consent to him to undergo that surgery, irrespective of the other siblings coming on board, I don't see a problem in that, because you can't get consent because the patient may not withstand the time frame of them arguing to give a consent. As long as the hospital has dictated based on common sense approach, listen, there are 8 of you, one give a consent. There's no need for all to give a consent. The patient is here, the patient is unable to give a consent. Who can come into her shoes? A proxy. And the proxy is not his rationale. He is governed by the Age of Majority Act. He can think for himself. He has given a concerted, informed consent after taking into account all the pros and cons of the risk. That the hospital shouldn't have a problem, sir.
all right. Thank you very much.
You're welcome, sir.
Assalamualaikum, Azrul. Hello?
Yes, Prof.
Yeah, Mr. Jaya, my name is Dr. Zamzuri. I'm the Director Clinical for SASMAC. I'm a spine surgeon as well.
Good,
So I got
good evening, sir. Good evening.
Number one, most of the time when I do my surgery, if I do cervical, or I do lumbar, or I do thoracic, I will take consent on my own. But sometimes because I'm in the management post, so my specialist will take consent from me, but he is the one who do the surgery, but I'll be doing the surgery with him.
Okay, sir.
So is it okay for him to take because I'm holding the post, because I'm the head of the service, I mean in spine unit, I'm the consultant there. So the responsible will come under me, even though the surgeon is taking the consent, because every time I do, my name will be there.
Okay.
So if let's say anything happens, so I'm the one who will be responsible, but the surgeon also will be responsible as well. But the
Yes.
burden comes big under my name.
Yeah.
So what is your suggestion? Is it suggestion when he take consent, I will be there, or I'm the one who must take consent for all my cases? Number
Sir,
one. Number
okay, sir. Okay, carry on, sir.
Number two, when taking consent, I like to draw. So most of the time I'll draw to the patient. So here in SUSMED, use THIS. So it's a THIS system. So it's very difficult to incorporate what I draw because I will draw on the paper.
Okay.
So the paper may be lost or the paper may be not there anymore when the patient, because most of the time with THIS, it's more on the computer.
Okay.
So I don't know either is it advisable to do both or is it advisable to do only take consent in hard copy. The consent is hard copy, but is it necessary to document everything in THIS?
Okay,
Number
sir.
two. Number three, when I take consent for major cases operating, so I'll ask the relative, let's say husband, if let's say the wife is involved, the husband, just to jot down there in the my consent on the written consent, either he also know and she also sign and put his number of his IC there as well. So is it necessary or not to do that?
Okay, sir. Sir, very valid questions. Thank you. Okay, the first part of the delegation, sir. So may I ask who actually conducts the surgery? Would it be?
Because sometimes the surgery is let's say I will do scoliosis surgery. So there are two surgeons doing the scoliosis surgery.
Okay.
Or sometimes I do neck surgery. So
Okay,
because
sir.
my specialist is under training, but I'll be there. I'm doing the surgery, but most of 80% maybe he's doing because he's part of the training program.
Okay, sir.
So but I'll
Sir?
be there. I'll be there and operate with him. So
Okay.
but the responsibility bear under me because
Yes.
I'm the one who's posed the case.
Yes. So under this situation, sir, as far as I see it, this unique scenario has not arisen in courts as yet. All the courts are looking for is that whoever has given the advice, let it be your good office or could it be your colleague, that advice was adhered to, that advice was accepted with clear mind by the patient. Because normally, sir, when surgery is done, please correct me if I'm wrong, there won't be one person. There will be a group of surgeons working.
Yes. Unless
so,
it's most of the time, like spine surgery, we do because they say even scoliosis surgery, there's even paper. Say
yes.
two surgeon will be good outcome rather than one surgeon. We
Yes,
have
sir.
papers on that as well.
Yes. So here, sir, you can be the front person to give the advice because it falls under your purview. But at the same time as well, if you think that, listen, for this particular surgery, I think I will not get the consent, somebody else a consent, I will only oversee, it's your call because there is no demarcation, sir. The consent is given to whom? It's only the consent is given.
Okay.
Because the hospitals have competent professionals who can carry on the procedure. So if, like, for example, sir, like you are with me, I'm following you, I'm also going to assist you in the surgery, but you are the lead. You may advise the patient of the pros and cons in detail and tell the patient that, listen, these are the team of people who will be working on you. Okay. The patient won't say that, listen, I only gave to Prof. Zamzuri, because he wouldn't know your name as well, so he would have forgotten your name, or he would have forgotten your face. But the issue is that what the law requires is that that consent given is informed in nature. That's all the consent is needed. So is delegated or not, that will not be a main criteria because the court will only look at the consent. Because you are the alter ego of the hospital, sir. Because you're working under what we call a vicarious liability scenario. You're working for the hospital. So whenever a person is sued, the hospital will be brought together as a party because they are vicariously liable for your actions. So generally speaking, as long as that particular informed consent is valid in law, irrespective who is addressed to, is irrelevant in my view. It is basically the operation is done by a group of people who are able and capable, and the consent was given not to you, sir. It is given to the hospital, because that's what the consent form is, not to the surgeon himself.
Okay.
Because the surgeon, okay, that's the first one, sir. The second one is that if you have any sketches or diagrams that you have explained to the patient, it will be a wonderful practice to keep those diagrams, because they are what we call primary evidence, because those evidence were done contemporaneously to the patient at the time of advice is being given. If you can log them up in a file, or you can download them in a form of any online attachment, please keep it.
Okay.
Signed by the patient and the doctor. Because why, sir? In law, we have under a particular section of the Evidence Act called documentary evidence. These documentary evidence are corroborative in nature. They give so much of weight to the verbal evidence.
Okay.
So when you have that, sir, if something were to come across later, you have, listen, I've even given her or him the diagram of what to be expected, what would the procedure be. So that will carry so much of weight in form of corroborative evidence. That's number
But the
two, sir.
diagram need to be signed, is it, Mr. Jaya?
Sir, you can sign it, or the patient can sign it, or it can be part and parcel of your treatment sheet, whatever it is. As long as the, okay, if you can sign it, sir, is far better.
Okay.
That will be far better. So the as regarding the consent of relatives that you were asking just now. So I missed that question. You were saying that if there are relatives, do you need to get consent from them as well?
Yeah. No, sometimes because you are doing the major surgery.
Yes.
So when you do the major surgery, the wife are there. So all the children are there, or the wife are there. They when we consult them. So the patient already give consent, but is it necessary to ask the wife to sign as well? As another.
Very well, sir. So as far as the law is concerned, is between the patient and the doctor relationship. The only time a relative will come in if the patient becomes incapacitated.
Okay.
Yeah, so the relatives they have no say in this, because most of the cases here, sir, that I've mentioned earlier, is all between the patient, doctor, and hospital. It's not the relative. The relative may come in as a additional witness for the patient, but if the patient is sane, he's able to part with clear-cut instructions, and his consent is informed, that's all is needed by law.
Even though when the patient even cannot write, you have to use a thumbprint or the second signature. Is it okay to get on what?
Yeah, you can, sir. Just to be, this is what, again, I'm coming back to the issue of corroborative evidence. If you feel at that particular point of time, the patient understands, but he's unable to put it on paper, then a thumbprint with a corroborative signature of the relative who's there would be very, very handy.
Okay. Thank you.
You're most welcome, sir.
Good evening, Mr. Jaya.
Hey, hi, good evening.
I just want to ask in regards to foreigner.
Okay.
Sometimes when they are incapacitated to give the informed consent, and what happened is quite tough for us to detect where's their next of kin from the country of origin.
Okay.
So sometimes what we can encounter is whether it's their legitimate employer here, local employer, or maybe a representative from embassy wise.
Yeah.
So what is your view in this kind of scenario?
Okay, this is it. The best option that I would advise is the embassy, because they are the alter ego of the person in this country, meaning that they are responsible to their own citizens. But if you are going towards the employer, you're right. Maybe the employer is not employing the patient as a legitimate employee. You may have legal complications later. And the time comes where something goes wrong, and you're looking for the employer who gave the informed consent, and he can't be found. There is where you cannot discharge your burden to show that you have given advice properly, as the Rogers test, which I mentioned earlier, or Fu Fiona's test, or Zulhasniza's test. So best option, foreigner, embassy.
Okay, thank
Do
you.
not go embassy. That would be the best approach, Kelly.
Okay, thank you so much, sir.
You're most welcome.
Mr. Rao, we have a question, I think on the chat box.
Okay, sir.
Maybe we can entertain the last few questions.
Sure, sir. Sure. My pleasure. All right. Yes, from Yang Mulia Raja Badrul and from Suryani.
Yes.
All right. Yang Mulia Raja Badrul, the question was, Mr. Rao, what is your view regarding a minor patient's consent to allow surgery to the child? Would that amount to a valid consent, although they understand the repercussions of a procedure? So this is where the problem is. This is a double whopper. We are saying that the parent is a minor and the child is a minor. So we're going to have a problem because the law is very, very clear under the Age of Majority Act. A minor can be a parent. All right. Just because she has a license as a parent doesn't mean that she can consent. We have never come across this scenario yet. It's a very interesting question, sir, but we have not. To me, I may call you later, or I can write to you later. Let me do some research on this, because to my view, a minor who is a parent is still a minor under the law, under the Age of Majority Act 1971. So I stand on the ground that she will not be able to give a particular consent to a child when the parent is also a minor. So I will do some research on that.
Can you have a proper advice on this, because we have few cases on this perhaps?
Oh, minors, is it? Cancer, of course, I will be more than happy to, because this is something that we'll do some research on, because I've never come across a minor mother and a minor child.
Especially pediatric.
Yes.
Patients.
Yes, because the law, looking at the law, sir, is very, very clear. Below 18, you can't give consent. And it doesn't say under the condition of caveats or conditions that unless the minor is already a parent. So I need to double check on that. I will definitely come back on that to you, sir. And the other one is that, sir, we have, it's from Suryani to everyone. Sir, we have a question from the Medical Records Department. As you said a moment ago, the Telemedicine Act has not been gazetted. If digital consent is acceptable, what? Jazrul, do you have the balance of the question, sir?
What act or statute is governed for it?
Oh, sir, this is it. The Telemedicine Act is not law in our country. Digital consent can be accepted via the Evidence Act. All right. So yeah, Evidence Act. You have all this new what we call that, this acts which have come forth now, where the law recognizes digital signatures, digital consents, as long as they don't impede the PDPA. There's a Personal Data Protection Act. So you can use the Evidence Act to cover that area, that when the consent is given digitally, it can be seen as a valid consent.
I think one last question from the chat box.
Yes, sir.
This is Millennium Area.
Okay.
Would it be a good idea to have a detailed explanation regarding certain procedure in YouTube? I mean, you instruct or you request your patient, or you produce the YouTube video. So if they, understand, they just sign, I think, on the chat box in the consent form, perhaps.
I think, sir, that is something that is too hard to explain because you're making it public. Now, Personal Data Protection Act is very, very clear. It's basically an agreement or an understanding between the patient and the doctor, which is highly privileged and confidential. If you are opening up that particular confidentiality to the world, YouTube is an open platform.
No. I think you have misunderstood the question.
Oh, sorry, sir.
I think what the intention of the question, we want to show to the patient the procedure as appeared in the YouTube.
Oh, I see the procedure. All right, this is it. Once you show a procedure to the patient via YouTube
Or video.
or video, you are subscribing to a procedure conducted by another person. It is not your procedure. So when you are parting the knowledge, sir, you're saying, look at this doctor did this is what I'm going to do as well. Sir, tak aci. Memang tak aci. Because that one, what going to happen, sir, you are using, and that guy, whoever that you are using him as a platform, he may have done that procedure. We do not know the accuracy of the procedure. It's not recognized. We wouldn't know. So first thing, any procedures adopted by a medical practitioner, it must be within his own personal knowledge and capacity. That knowledge must be passed on. So let's say, for example, sir, if that is the scenario and I am the patient, the first thing will come to my mind is that, hey, you're copying somebody's procedure. How sure are you sure? Because I rather the maker do the procedure on me than the person looking at the procedure and telling me that he can do it. Then I'm going to have a problem. So that will not really work in the real sense. And that will open up floodgates.
On top of our explanation, kita nak tunjuk, ni macam ni lah lebih kurang.
So what you can do is that you can say, hang rujuk kat YouTube ni lah, but don't show him the YouTube. If you can, you just rujuk kat YouTube tu saja, jangan tunjuk, because this YouTube, sir, this is it. We do not know the accuracy because YouTube has a disclaimer clause. We do not know the accuracy of that procedure. Now, like what Dato' Muhammad Safi, Prof. Zamzuri said, when you are doing the procedures, you are going to come across certain events which are unforeseen. Then you're opening up to floodgates of a medical negligence suit. So my advice, try not to.
Takut yang YouTube tu yang indah-indah je.
Yes, dia orang buat indah-indah saja. We do not know what the procedure is. Because on top of that, that will not fall under informed consent because that is not you. You are asking them to look at something else and saying that I can do that.
Jaya, extension to my question just now in regards to foreigners.
Yes.
May I extend the complication of the scenario whereby they are those unrecognized foreigners, those with bogus passport, for example.
Okay.
So we could not identify the exact embassy that belongs to them.
All right.
In that particular event, if the employer were to make themselves appear and tell, that will be common sense and we can accept in that particular scenario, is that fine?
All right. Now, Kelly, when this patient comes to see you, all right, are they already in a, because to get the informed consent, the patient must undergo something more drastic.
Okay.
All right, this is not like coming and taking a Panadol, giving a flu capsule or flu syrup, etc. All right.
So this is the scenario that really they are incapacitated to sign the form, and we are finding for the next best person to sign the form.
Next best person. That's why I say, if you cannot, for example, you cannot get the embassy because we do not know his status.
Yes, yes.
But you have the employer.
Yes.
Get all documentation from the employer first.
Yes.
Number two, get the passport. Of course, the employee will come with a passport.
Okay.
Double check the passport and look at his point of entry because he must have left a country looking at the passport.
Okay.
Then you can verify which country he's coming from. If the employer comes clean and say, listen, this guy is illegal, I just took him to work about a week ago.
Yeah, that kind of scenario. Huh?
Yeah, scenario, right? Then you ask the employer to be responsible.
Okay.
Take all particulars of the employer and say that I am doing this procedure based on exceptional circumstances because we are unable to dictate, because there are caveats, Kaylee, like we said earlier, if it's an emergency.
Okay,
you
sure.
don't need to have the informed consent. If time is of essence, you don't need to have the informed consent.
Okay.
But if you can't get any of these people, the next best person is the employer. Get the employer. And mind you, right? Mind you, Katie, with deepest respect, this kind of candidates, they will not sue the hospital or the doctor. All right? Because what, they are illegal in nature anyway.
Okay.
I'm not saying that, oh, you can freely do it, but I'm just giving you a caveat that from experience, right?
Yeah,
Most of these people who have no proper documentations, they will take and leave the hospital.
Okay, thank you so much.
Okay, all right. But please
We have last question.
tread with caution. Is there one question, Jazrul? From Zoraida binti Hassan. Yeah, hi Zoraida. Hi. Mr. Rao, what about in the cases of patient having a language barrier? Explanation done through patient's relative accompanying person, but might not be effectively translated. Thank you. All right. Now, I think that you do have Zoraida in the what we call that in the Malaysian Medical Council Guideline Para 8. All right. Now, it says a consent. Yeah, what it says, I'm just reading it you ad-libbing it to you. It says that a valid consent or informed consent must be given by the person with legal capacity and or of sufficient intellectual capacity to understand the implication of undergoing the proposed procedure. That's number one. Number two, it must be taken in a language which the person understands. That's your questions. Yeah, your question. Now, when we come to this language issue, Zoraida, you can do your best, meaning that if he can't speak, can he put it down in writing? So, mind you, the connection between the meetings of mind, like which I've said earlier, consensus ad idem, it does not need to be language per se. The explanation can be done through writing. So if you think that it is not, there's a translator, it's not effectively translated to him, see whether that patient can read and write. That will be the first option that I will think of being the most logical option. Number two, if he is illiterate, then you're going to have a problem, right? Find out what language that he can speak. Then work it from there. Because your question is very relevant, Zoraida, because the person who is translating may not be available if matters move into court. Then the patient said that, yes, I was not given a proper translation because I can't read and write and I can't speak the language. Then you're going to have a problem. So please tread carefully when it comes to the translation. The person is capable. It could be what? In Malaysia, we have 3 languages or 4 languages. Foreigners, what languages? Try to see where they can help. If you can't, if it's a foreigner, go for the embassy. Always embassy will be your best bet. I hope that that assists in a way to answer the questions, Zoraida.
Yes, thank you, Mr. Rao.
You're most welcome.
I think I pass back to our Master of Ceremony, Sister Suraini.
All right. Thank you, everybody. It's a pleasure, and I wish you all very well, and please stay safe and have a wonderful weekend.
Thank you, Mr. Rao, for an informative and interesting talk. Ladies
Thanks,
and
Rani.
gentlemen, ladies and gentlemen, may we thank you for your participation in this webinar. We hope you enjoy the program. Have a safe trip back home. Stay safe. With that, we end our webinar with Tasbih Kifara and Surah Al-Arsh. Thank you, everyone. Thank you, sir.
You're welcome. Bye, Rani. Take care. Bye-bye.
Okay, bye.
Thank you.
Thank you, Mr. Jaya.
Welcome, one. Thank you very much for your time. Thank you. Guys, how to come up, please?
Thank you so much.